Ladies and gentlemen of the jury, Your Honour, officers of the court, and members of the public. May I start by introducing myself, Peter Young. I lead for the prosecution in this case, and my learned friend Terry Nicklin leads for the defence. We are not, of course, barristers at law, although I did study law at university many years ago, and I am a lifelong sucker for any book, TV show or movie which features a trial, from 1950s Perry Mason to 21st century Suits, a series which I highly recommend to anyone who has Netflix, and which, incidentally, features our new royal mum, the Duchess of Sussex, as an aspiring lawyer, and a pretty good actress she is too, portraying a very good young lawyer. Both I and Terry may not be authentic barristers, but we do, however, know a thing or two about marketing, a profession and a discipline which we both love, at its very best and even at its worst, and of which we have a bucket of experience between us. There would, in a real trial at the Old Bailey, of course, be junior counsel, but austerity is austerity, the CIM is the CIM, and budgets are tight. And, of course, Brexit is Brexit. It is, of course, to blame for everything, and the money for juniors has probably been spent on ferry companies without boats, preparing to cope with a no-deal Brexit, which may or may not come in my lifetime. Even my budgeting is better than that. There, we've been able to shoehorn 10 seconds of Brexit into a trial of marketing. On a more serious note, we will today be examining two serious charges brought against marketing, which I will now read to you. Charge number 1, marketing has failed to demonstrate to business how it creates value for customers and shareholders. Charge number 2, marketing has failed to provide practitioners and those aspiring to practice the skills they need to create value for customers and shareholders of a business. In the next 2 hours, we will examine the testimony of 4 witnesses. 2 witnesses for the prosecution and 2 for the defence. Prosecution witnesses will present testimony in response to my questioning and will be subject to cross-examination by Terry. Defence witnesses will present testimony in response to Terry's questioning and will be subject to cross-examination by me and those of you who can manage Twitter, which, fortunately, I don't have to use, as I would certainly make a massive hash of it. Pause for laughter at one pathetic pun. At the end, counsel will sum up. I will sum up for the prosecution, Terry will sum up for the defence, and then the judge will sum up for the court. The jury will retire and will in due course present a verdict of guilty or not guilty on each count, which may be by unanimous or by majority vote. We find ourselves in an unusual venue, a court of law in a university. Both may be seen as cradles of a civilized society. For hundreds of years, here and in universities across the planet, knowledge has been generated, nurtured, debated, stored and disseminated, passed on to the benefit of future generations. The Spanish have an old saying that only the human animal trips over the same stone twice. They are probably right, but at least the universities may shine a light on the stone so that we may avoid tripping over it, if we so choose. And here in a court of law, justice is done, and seen to be done. Conflicts are resolved without recourse to the shedding of blood and brains. Fans of Game of Thrones will recall few law courts featured in that saga of dysfunctional civilization. Here in a law court, individuals, rich and, so much more important, poor, are protected from undue invasion of their inalienable right to life, liberty and the pursuit of happiness, to quote from the US Constitution. Here in the relative quiet of a law court, reason prevails over emotion. Here civilization meets and cares for the needs, aspirations and fears of the common man. And yet, as we walked across the campus from the car park, a colleague warned me not to expect too much today. It's no big deal, it's just a start in a small hall with a small audience. But that made me think of another small hall in Philadelphia, the Carpenter's Hall, which too in 1774 played host to a small crowd. The attendants, somewhat grandiosely, called themselves the First Continental Congress. It was a stretch to call it continental, consisting as it did of the unelected representatives from 13 small, rowdy crown colonies, and only slightly less of a stretch to call it a Congress. But they muddled through, made a few decisions, and the next year, thanks partially to the intervention of a couple of lightweights called Benjamin Franklin and Thomas Jefferson, the Second Continental Congress, which didn't fit into the Carpenters, signed the Declaration of Independence, which spawned the American Constitution, led to the War of Independence, and the rest is literally history. Surely at least one delegate in 1774 said to another, "Don't expect too much of this. It's no big deal. Small hall, small audience." One has to doubt we will take the first steps today to a whole new world order, but perhaps what we do today may be the start of something big for us marketers, the rehabilitation of marketing. Because here in a courtroom, as in the Congress, but unlike in a university, the matter does not end with the debate. In a university, there is a continuous gathering of data, an assessment of data, and an analysis of its significance, and decisions may be reached, but there is no consequent action. Here in a law court, as in the world of management, there is indeed action. Without action, we are nothing. A trial is not an end in itself. It is about justice. It's the beginning. Of course, if an accused is found not guilty, he or she starts a new life with a clean slate. He or she is liberated. But for the guilty, a trial is not just about Old Testament punishment, retribution, revenge. Yes, a guilty verdict results in action, a sentence. But the sentence is but a start, the start of rehabilitation, the eventual return of a lapsed citizen to his or her proper role as active participant in, contributor to, and beneficiary of a prosperous and fulfilled community. And that is the fate of marketing today. If innocent, marketing goes on its way. If guilty, marketing can take the first steps to rehabilitation. And so, to put marketing on its much-needed path to rehab, the prosecution will now demonstrate marketing to be, beyond reasonable doubt, guilty as charged. Permit me to introduce our first witness, Keith Rowland.